Students to the CA Foundation Come Clat lecture series sponsored by Sri Jendra Rank Zone. This is lecture number 2 in the Indian Contract Act 1872. I am your mentor Shekhar Gehlot. So we are now discussing the essentials of a valid contract. The other essential is consideration. Now we have already discussed consideration in brief. Let us somehow understand in detailed manner. It is referred to as quid pro quo, something in return. Quid pro quo is a Latin phrase which means something in return. Okay, a valuable consideration in the sense of law may consist either in some right, interest, profit, or benefit accruing to one party or some forbearance, detriment, loss, or responsibility given, suffered, undertaken by other party. So, what is this consideration? So, first of all, understand the very basic meaning something in return. I do something for you, you do something in return for me. Suppose now, in the example, that's it. Very basic example and very easy to understand. I sell rice to B. What I'm giving to B is rice. Quid pro quo, and I'm getting something in return. I'm getting in return 50 rupees. 50 rupees is quid pro quo. Or for B, it may be he's paying 50 rupees and his quid pro quo or something in return is rice. So here for me, consideration is rice because I am giving rice, and B is giving 50 rupees. For B, consideration is 50 rupees. Okay. A valuable consideration in the sense of law may consist either in some right. Okay, either in some right. Let us talk about farmer bill. Okay, farmer bill. It says farmers have a right to sell the produce even before it is good for even before it is cultivated. Now, Reliance, I will buy a crop. Reliance enters into a contract with the farmer B that I will buy a crop at 25 rupees kg. Here in this case, till now crop has not harvested. What quantity of crop is going to be harvested? What grade of crop is going to be there? This is not still decided, but what farmer has agreed now. Now, in this case, what is the consideration for farmer? Consideration for farmer is 25 rupees per kg, whatever kg it's going to be ultimately. And Reliance, what is the consideration is some right. Reliance gets a right. Reliance is getting a right, a future right, that tomorrow when the crop will be harvested, I will take that crop. So consideration can also be a right. Interest, okay, like in the finance sector, the bank gives us loan and it gets some interest over it. So that interest is the consideration. Okay, interest is the consideration. Some profit, okay, some profit, like now farmer is getting 25 rupees. Earlier farmer used to get 15 rupees only. So now farmer is getting 10 rupees extra per kg. So that is the farmer's profit. So the profit becomes a consideration. Benefit accruing to one party or the benefit in any manner. Okay, these are benefits. Right, interest, profit, benefit. These are benefits. Okay, or some forbearance. I will not do that. Okay, some forbearance. Suppose A employs B at. Okay, now this is a composite contract. It has so many parts. A employs B, an engineer, at a salary of 100 rupees. A says, you work with me, I'll pay you 100 rupees. That's it. But I can pay you 200 250 rupees per month if you After you have stopped working with me, suppose you have retired or you have quit my company or company has shut down, you will not employ yourself after quitting the job in the similar company, similar type of company. If you promise to do that, I'll enhance your salary to 250 rupees. Okay, so in this case they are both getting a benefit is accruing to both the parties. But here he will be, B accepts the consideration, accept the contract. For B, the consideration is 250 rupees. But for A, the consideration is his forbearance, B's forbearance to employ himself in similar employment later on. Okay, that is forbearance. He will get 250 if you do not employ himself. That's it. So for A, in this case, the forbearance is the consideration that you do not employ yourself anywhere else. What is the benefit to the A here? Because A will train the B in his company, and B will get access to a lot of technological secrets of A. So if B will not employ himself to anywhere else, A's secrets will remain secure. Okay, he will not face tension from the market. Detriment, some loss, like he is B suffering some loss here that he could not employ himself tomorrow. Responsibility given, suffered or undertaken by other. Okay, something suffered by or undertaken by other person. These are called considerations. He agrees to sell his books to B for 100. B promised to pay 100 is the consideration for A's promise to sell his books, and A's promise to sell the book is the consideration for B's promise to pay 100 rupees. Okay. Lawful consideration and object. So the consideration should not only be a consideration, the consideration should be lawful as well, and the object should also be lawful. So whatever in the contract we do, it should be lawful. If it is not lawful, it won't be enforceable at the court of law. And if something is not enforceable at the court of law, it will cease to be a contract. It will merely just be a agreement only. Okay. The constitution and object of the agreement must be lawful. Section 23 states that consideration or object is not lawful if it is prohibited by law or it is such as would defeat the provisions of law. If it is fraudulent or involves injury to other person or property of another, or court regards it as immoral or opposed to public policy. Okay, this is very exhaustive. See, definition. Okay, unlawful object similarly, just like A will pay B if he commits theft. Okay, now committing theft is the unlawful object. Or A will pay stolen gold to B. Here the stolen gold is the consideration. Here the theft is the object. Here the stolen gold is the consideration. So this stolen gold is, it does not belong to A. Okay, it is not lawful. So this consideration will not be a valid consideration here. Okay, it is prohibited by the law, or if it is such as would defeat the provisions of the law. It is such as it would defeat the provision of the law. If it is fraudulent, it's fraudulent like we discussed. Fraudulent consideration is no consideration at all. Okay, or it involves injury to other person, property of another, or court regards it as immoral or opposed to public policy. Immoral or public policy. Okay. A contracts with B for promoting Hindu religion. That is perfectly legal, nothing wrong here. But not only he'll promote Hindu religion, but he will demonize other religions as well. Okay, he'll say that Muslim, Islam, or Christianity or Jain religions are bad. So this becomes, it is opposed to public policy. Our public policy, all religions are good, all are equal. Okay, so if this part, the contract is ends here for promotion of Hindu religion, it's valid. Object is valid, consideration is valid. but he says he would demonize the Hindu religion or other religion, then it becomes opposed to the public policy, or it may be immoral, some contracts for the nudity or the obscenity which are immoral, which are not followed by our country, some standards. Okay, so in these cases the consideration will become immoral or object will become immoral. A promises to drop prosecution instituted against B for robbery, and B promises to restore the value of things taken. The agreement is void as the object is unlawful. Okay. A promises that I will not proceed you against in the court of law. Some prosecution is going on for some committing some crime, for committing robbery. And B promises that I will pay back the things which I have committed robbery. But this is not valid. Why? Because law says the crime and the criminal both has to be punished. Okay. B cannot just by paying money go away free after committing robbery. If he has committed robbery, we will take the money as well as we'll send him to the jail. Okay, so any contract by A that I will drop the case against you, you pay me back. This thing is against the public policy. It is immoral as well, so it is going to be declared void. Not expressly declared to be void. Okay, the object of the law should not be such that it is expressly declared void. Expressly declared void means in writing, it is in writing declared void. There are some kind of agreements, some agreements which are declared void by the Indian Contract Act. So this should not be such kind of agreement which is in writing declared to be void. The agreement void means something which cannot be enforced in the law. Why? Because law will deem that such kind of agreement never existed. So something which never existed cannot be enforced also. The agreement entered into must not be which the law declares to be either illegal or void. An illegal agreement is the agreement which expressly or impliedly prohibited by the law. A void agreement is one without any legal effects. Threat to commit murder or making publishing defamatory statements or entering into agreements which are opposed to public policy are illegal in nature. Okay, threat to commit murder, that you do this or I'll commit murder to you. You sell your property or I'll commit murder. Okay, you give this to me or I'll make defamatory statements against you, or I'll make illegal statements against you, false statements against you, that you are bad character, that you molested me. I'll launch a false case against you, or you give me promotion. Enter into agreements which are opposed to public policy. You do one thing, you say bad things about Muslim religion or Hindu religion, spread hatred. These are illegal in nature. Okay, so they are going to be void. Agreement and restraint of trade. Okay, these are those examples which are written, okay, which are written by the Indian Contract Act, okay, which are written by the Indian Contract Act, which are going to be void. Agreement and restraint of trade, marriage, legal proceeding, etc are classic examples of void agreements. Any agreement and restraint of trade. I will pay you 100 rupees if you promise never to work. That is agreement in restraint of trade. You cannot stop someone from working. Okay, you cannot make all the half of the population employed by saying that I'll pay you 100 rupees. Okay, agreement in restraint of marriage. I'll pay you, I'll sell you this land. I transfer my land to you if you promise to stay unmarried. Okay, now B says, okay, I will not marry. After taking land, B marries. Now A cannot get back his land. Okay, because it was a void agreement. It was a void agreement. Okay, legal proceedings like dropping the case, etc are classic example of void agreements. These are some cases in which consideration as well as the object is void. So these kind of agreements are declared void. Object may not be unlawful, but they are expressly declared void. Types of contract on the basis. Okay, now we will understand what types of contracts are there and what are the bases. So, contract on the basis of validity of and or enforceability. What type of contracts are there on the basis of validity? Valid contract, voidable contract, illegal agreements, unenforceable contracts. Okay. Similarly, on the basis of formation, express contract, implied contract, quasi contract, e-commerce contracts. On the basis of performance, executed contract, executory contract, unilateral executory contract, bilateral executory contract. These are the types of or classes or categories of the contracts, and how these are subcategories of contracts, and these are further classification on the basis of performance, formation, and validity or enforceability. Now we'll discuss them individually in brief. On the basis of validity, a valid contract. What is a valid contract? An agreement which is binding and enforceable is a valid contract. It contains all essentials of elements of valid contract. Okay. So Contract Act says that you have to follow point A, B, C, D in order for a valid contract. So any contract which follows all the point A, B, C, D in letter and in spirit, it will be a valid contract. Very easy. Then void contracts. We have just discussed what things can make a contract a void contract. Okay. Section 2 states a contract which ceases to be enforceable, which ceases means stops to be enforceable, which is no longer enforceable by law, becomes void when it ceases to be enforceable. Okay. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. That means at the moment it became it ceases to be enforceable, it becomes void then and there only. It becomes void then and there only. No future will come for that kind of contract. Thus, a void contract is one which cannot be enforced by a court of law. Mr. X agrees to write a book with the publisher. After a few days, X dies in an accident. Here, the contract becomes void due to the impossibility of performance of the contract. The moment he died, then and there, okay, the moment he died, then and there, the contract becomes void. Before his death, the contract was a valid contract. Okay, before his death, the contract was a valid contract, nothing illegal with this. But the moment he died, it became a void contract at that moment. Why? Because now the contract has become impossible to be performed. So you cannot enforce a contract which is now impossible to be performed. A contracts with B, owner of the factory, for supplying of 10 tons of sugar. Okay, 10 tons of sugar, but before the supply is effected, the fire caught in the factory and everything was destroyed. The fire caught in the factory and everything was destroyed. Here the contract becomes void when the fire caught. Okay, then and there. It may be added by way of clarification here that when a contract is void, it's not a contract at all. But for the purpose of identifying it, it has to be called a void contract. Okay, so we know a contract is a contract which is enforceable by the agreement, which is enforceable by the law. When void contract cannot be enforced by the law, why do we call it a void contract? We only call it a void contract only for identifying such contracts separately from other contracts. Okay, otherwise there is no such category as a void contract. But in order to understand in theory and in practice, it is referred as a void contract. Now, voidable contract. This term voidable means two things. Okay, a void contract is a contract which cannot be fulfilled at all. Okay, just like we discussed in the case of company law, a memorandum of association, ultra vires act. In MOA, if the company is committing an act which is ultra vires to memorandum of association, it becomes void ab initio. Even if 100% of the shareholders vote in favor of that act, this act will never become a legal act. Okay, so that is a void act which never existed. Okay, but there is a voidable contract. In this, there are two options available. Okay, with the person, which person who has suffered loss in the contract, which person who has suffered some loss in the contract. This is the person who has the choice. He can either treat this contract as a void contract, that this contract never existed, or he can follow the contract as if nothing happened. Okay. Now A threatens B with murder. A says that I will murder you. B, I will murder you if you do not transfer your land to me, if you do not sell your land to me. A is a criminal, B is a normal person like you and me. Now A threatens B if he does not transfer land to A. Okay. B transfers land. B transfers land at 50% value. Okay. So now this contract is now a voidable contract. Okay. You may think that this person is threatening him with murder, so it becomes a void contract as well. Okay, definitely it will become a void contract, but only when B will come to the court and say that he threatened me with a murder. Okay, now B has two options. B can sit silently and follow the contract. Okay. There may be so many reasons. B is so much afraid of the A that if I go to the police or the court, A will kill me. So now B has no option. B will just sit silently. B will say it's okay, I have got 50% of my land. I am okay with this. In this case, the contract is going to be very valid contract. Okay. Because other than B, no one can go and tell that his consent was taken by threat. B says, no, no, my consent was taken with my permission. It's a free consent. So this agreement is going to be valid in this case. Okay. Or he can complain to the police against this thing after the sale and treat the contract as void and then get his land back and return his 50% money to the A. Now he has the option. Who has the option? Who has suffered loss here? B has suffered loss. Why B has suffered loss? Because B is compelled to sell his land at 50% lesser value, half value. So now he has two options. He can sit silently and follow the contract, or he can complain to the police. Okay. So this is a voidable contract in which the party who has suffered a loss, it has a power to decide whether to be accept this contract or not to accept this contract. Now I'll give you another civil example. You may be a bit confused. Suppose A A enters into contract with B to stitch a sari, which A will wear in her wedding, and wedding date is 29 November 2020. Okay. Now Now B did not deliver sari by 29th November. Okay. But definitely marriage cannot be postponed just for a sari. Okay, so B did not deliver sari on 29th November. A wore something else and marriage was completed. On 3rd December, B delivers sari. Now A has two options: either to accept sari and pay. A may say it's okay, wedding has already happened now, what is the use of crying over spilled beans? Okay, and treat the contract as a regular contract. Okay, if the A treats the contract as a valid contract and accepts the sari, she has to pay. Or she may refuse to accept the sari and she may refuse to pay. Now here this contract is going to be void contract. Okay, so now you understand there may be any number of examples. An example which is a criminal kind of example, an example which is a civil kind of example, though both of them can happen any day. Okay, so now you understand the basic difference between a void contract and a voidable contract, and what is a voidable contract. Now let's read. An agreement which is enforceable by law at the option of one or more parties thereto, but not the option of other or others is voidable contract. Okay. Now an agreement which is enforceable by law at option of one or more parties. One party at option of one party, but not at the option of other party. Now let us go back to the examples again. In this case, B has the option, okay, to treat the contract either as a valid or to void the contract and complain to the police. But A does not have any option here. Okay, if B goes to the police and makes a complaint and treats the contract as void, A does not have any option here. The contract will be void. A has no option to go to the police and say, no, this is a valid sale. Though I have committed an offense, but offense is different, but transfer of the property has taken lawfully. This is not the case. A does not have any option. Or in this case here, okay, B delivers sari. B cannot say that I have delivered the sari. My contract was to deliver the sari. Marriage may have happened. I could not deliver on 29th, but now I am delivering the sari on your order. You must pay me. B does not have any option here. Okay, only A has the option. Only the one who has suffered loss has the option. Okay, B or in this case A, they don't have any option because they are defaulters. Defaulters don't have any option. The one who have committed the breach of contract does not have any option. The one who has suffered the breach of contract or an illegal contract, they only have the option. This in fact means where one of the parties to the agreement is in a position or is legally entitled or authorized to avoid performing his part, then the agreement is treated and becomes voidable. Okay, this in fact means where one of the parties here B, or sorry here A, to the agreement is in a position or is legally entitled. Now she is legally entitled to refuse the sari or authorized to avoid performing his part. She is legally entitled to not to accept sari. Okay, then the agreement is treated and becomes voidable. Okay, such a right might arise from the fact that the contract may have been brought about by one of the parties by coercion like this, or undue influence. Suppose there may be a case of some guru or some employer or someone in authority like a police person. In undue influence, like a police person may say that I'll drop the case against you if you do this favor to me. Fraud, like basmati rice case we discussed. Misrepresentation, okay, and hence the other party has a right to treat it as a voidable contract. Okay, mistake is always a void contract, like we have already discussed. Mistake is a void contract, otherwise it's a voidable contract. At this juncture, it would be desirable to know the distinction between void contract and a voidable contract. The distinction lies in three aspects, namely definition, nature, and rights. Okay, there are three lines of distinction between void contract and avoidable contract. The three paradigms are Definition, nature, and rights. These are elaborated here under. A void contract cannot be enforced at all. A voidable contract is an agreement which is now definition is a void contract cannot be enforced at all. Cannot. That's it. Gone forever. Avoidable, on the other hand, is a contract in an agreement which is enforceable only at the option of one of the parties but not at the option of other party. Therefore, enforceability or otherwise divides the two type of contracts. Okay. In the definition, void can never be enforced by either party, but voidable, one party has the option. Nature. A void contract is valid at the time when it is made but becomes unenforceable and thus void on account of subsequent developments or events like supervening impossibility, subsequent illegality. Okay, a void contract was usually a valid contract. Okay, initially it was a valid contract, that's why we call it a contract. It was a valid contract, that's why it was a valid contract. But later on, it became void. Why? Due to supervening impossibility. Like we discussed the earlier case, A enters in a contract to publish a book for a publisher, but write a book for a publisher, but A died. That is a supervening impossibility. Now it is impossible. Or subsequent illegality. Now A agrees to export 100 tons of onions to B in England. Okay, but after some time, the government of India, due to shortage of onion in our own country, banned the exports of onion. Now no one can send onion outside India. So now this contract has become void because now he cannot sell it because there's a prohibition by the government of India. So subsequent illegality, etc. Okay, and there may be some more situations like this, but definitely we cannot discuss each and every possible situation here. Repudiation of a voidable contract. Repudiation means treating it as cancelled. So, in a voidable contract, when other party treats the contract as a cancelled contract or a null contract, it also becomes a void contract. Okay. Similarly, a contingent contract might become void when the occurrence of the event on which it is contingent becomes impossible. Okay, contingent contract we'll do later on. On the other hand, voidable contract would remain valid until it is resigned it by one person who has the option to treat it as voidable. Voidable contract will automatically will not become void. In these cases, the contract will automatically will become void. Here, the moment person dies, it automatically becomes void. Here, the ban is imposed, it automatically becomes void. But in these cases, the voidable contract will not automatically become void. It will remain a valid contract, but it will remain void. It will become void only when the other party who has a right to declare it as a void uses that right, okay, to declare the contract void. All contracts caused by coercion, undue influence, fraud, misrepresentation are voidable. Generally, a contract caused by mistake is void. We have discussed this, so doesn't need further explanation. Rights. What are the rights? What is the difference between voidable contract and a void contract on the basis of rights? What are the rights? As regards rights of the parties, in case of a void contract, there is no legal remedy for the parties, and the contract cannot be performed in any way. In case of the voidable contract, the aggrieved party has a right to resign it within a reasonable time. If it is so resigned, it becomes void. If it is not so resigned, it becomes a valid contract. So in void contract, there is no right with any party. Okay, nothing could be done. But in the voidable contract, one party has a right to choose to decide whether the contract is going to be void contract or not. Differences can be summarized as under void contract, voidable contract, meaning a contract ceases to be enforceable by law becomes void when it ceases to be enforceable. or an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. A contract becomes void due to change in law or change in circumstances beyond the contemplation of parties. Change in law, like we discussed, the prohibition on the export of the onions, or change in circumstances beyond the contemplation of parties. A contract becomes a voidable contract if the consent of party was not free. Okay. Performance of the contract, a void contract cannot be performed. Definitely, void contract cannot be performed due to impossibility of performance or, or so many other factors. But in the voidable contract, if the aggrieved party does not, within reasonable time, exercises his right to avoid the contract, any party can sue other for claiming the performance of the contract. Okay, within reasonable time. Suppose A threatens B that I will kill you if you do not transfer the land to me. Okay, now B has transferred the land to A. Now say for 20, 30 years, for 15, 20 years, B does not complain. Okay, and meanwhile A has now sold this land to someone else, and someone else has sold this land to someone else, and now land has reached to some 5, 10 other parties. Now 20 years later B comes up to the court and says that 20 years earlier A threatened to kill me if I did not sell my land, and out of that coercion I sold this land. So that land transfer should be cancelled and land should be returned back to me. And now land has already gone to 20, 30 more people. Now this can't be done because he should have come within a reasonable time. Okay. The person maybe, if he definitely proves, he is able to prove that there was a threat. The person may be tried for the offense. A may be prosecuted for offense of extortion, but land will not come back. Okay, land is gone now forever because he did not come in the reasonable time. There may be other repercussions, but definitely contract will not be treated as void now. Rights. A void contract does not grant any right to any party. Like we have discussed, the void contract becomes non existence for all. When something never existed, then what right you will have over a thing which does not exist? A party whose consent was not free has the right to rescind the contract. Okay, a party whose consent was not free has a right to rescind the contract. Illegal contract. It is a contract which the law forbids to be made. Okay, illegal contract is such a contract which the law forbids to be made. Forbids means bans or prohibits or does not allow. Okay, the court will not enforce such a contract, but also the connected contracts. Okay, the court will not enforce such a contract, but also connected contracts. All illegal agreements are void, but all void agreements are not necessarily illegal. Okay. So illegal contract is definitely a illegal void contract. Okay. All illegal agreements are void, but all void agreements are not necessarily illegal, like we discussed in a case where, in some cases, void agreements before becoming void, like export of onion or writing a book for the publisher, they were not illegal, they were valid. But later on, they became void because of so many circumstances out of the control of all the parties. But an illegal contract is always a illegal agreement is always a void agreement. Like I enter into agreement that I pay you 2 lakh rupees to commit a murder. That is always a illegal agreement. Contract that is immoral or opposed to public policy are illegal in nature. Okay, public policy is a very broad term. So many things can be put up into this bracket, but anyhow, that is not our field of research right now. Similarly, if R agrees with S to purchase brown sugar, it is an illegal agreement. Okay, brown sugar is
It's 8 o'clock.
illegal. Okay, it is against the public policy. Our public policy is that we do not permit the sale and purchase or consumption of brown sugar. But when he is doing so, that is against the public policy. That is illegal as well. Okay, so it becomes illegal. According to it, it becomes void. Sorry. According to Section 2G of the Indian Contract Act, an agreement not enforceable by law is void. The Act has specified various factors due to which an agreement may be considered as void agreement. One of these factors is unlawfulness of the object and consideration of the contract, i.e., illegality of the contract, which makes it void. Okay, even consideration may be unlawful. Consideration may be unlawful, not only object. Even consideration may be unlawful, like we'll discuss. Here in this contract, the contract is perfect. It's a valid contract. There's no issue with this agreement, okay? Definitely, you can enter into a contract for sale and purchase of rice, but it becomes a void contract because the B agrees to pay brown sugar worth rupees 4 lakh. The consideration here is brown sugar, which is prohibited, so the consideration becomes illegal. The contract is not illegal, but the consideration is illegal. So the whole contract will become automatically illegal and void because consideration has to be a valid consideration. The illegal and void agreement differ from each other in the following respect. Now let us do the differentiation between the illegal and void agreements. Now we have done the difference between void and voidable. Let us discuss the differentiation between illegal and void agreements. All illegal agreements are void, first of all. Okay, we have discussed all illegal agreements are void. However, all void agreements are not illegal. Despite this, there is similarity between illegal and void agreement, that in both cases it is void ab initio and cannot be enforced by law. Okay, it is void since inception and cannot be. This is the similarity, that both are void and cannot be enforced, but every void agreement need not be illegal. Nature and character. Illegal agreements are void since the very beginning. They are invariably described as void ab initio. Illegal agreements are void since the very beginning. They are described as void ab initio. Void ab initio is a Latin term which means void since inception. Void right the moment from since the moment they were entered. Right from the beginning, they have been void. Illegal agreements are right from the beginning, they have been made. But as already emphasized under the scope, a contract by nature, which is valid, can subsequently change its character and can be void. Okay, illegal agreements will be void since inception. But all void agreements are not illegal. All void agreements are not void since inception because they may become void later on. Okay, they may become void later on subsequently due to some changes like impossibility or change in law, something like this. Effect on collateral transactions. In case of illegal contract, even the collateral transactions, namely transactions which are to be complied with before or after or concurrently along with the main contract, also become not enforceable. In contrast, in the case of voidable contracts, the collateral transactions can be enforced despite the fact that the main contract may have become voidable to the extent the collateral transactions are capable of being performed independently. Collateral transaction means Okay, some important part of contract or things which are attached to the contract. In case of illegal contract, all the part of contract will become, even the collateral will become illegal. Okay, will become illegal. Like say, A pays 20 lakh rupees to B for corruption. Okay, now A has given 20 lakh rupees to B for corruption. Now police comes to know that they are involved in corruption. Okay. Now whatever act they have become has become illegal, plus the contract has become void, plus this 20 lakh rupees. Neither B will keep it nor A will keep it. This will become the property of state. Government will confiscate this 20 lakhs rupees. This is the collateral. Okay, important part of the contract. Things attached to the contract. 20 lakh, this collateral will become government's property now. A will go to the jail, B will go to the jail. Neither will be able to perform the contract, and the 20 lakh rupees will also be given to the government. A pays 20 lakh to B for export of onions and beans. Okay. In this case, government bans the export of onions. Now onions cannot be sent, but beans can be. Okay. So in this case, A will definitely send beans to B. Okay. A cannot say I will not send even beans now. A will have to send beans. Or suppose now there is a ban on export of beans as well. Now A can ask him give me my 20 lakh rupees back, give me 20 lakh rupees back. Okay, so he'll have to give 20 lakh rupees back. These are the collateral which can be still performed. This part of contract still can be performed. Okay, he can still ask him to pay his 20 lakh rupees back. This part of the contract cannot be performed. Or if only onions are prohibited, only this part of the contract is void, other part is still valid. A B can still supply beans to the A. Okay, so everything will not become illegal here or void here. In this case everything has become illegal and void. 20 lakh is also void. What B did after taking this 20 lakh is void. What benefit A got is also void. Everything is void. But here, because the contract was valid, later on it became a void contract. Okay, so in this case it's not an illegal contract. In this case it can be still performed in parts. It is not overall void, illegal. Penalty or punishment. All illegal agreements are punishable under different laws, says like Indian Penal Code. Like in this case, anti-corruption law, this is punishable. Whereas parties to void agreements do not face such penalties or punishment. But in this case, there is no such punishment or penalty. Okay, there is prohibition on the ban of onions. Now he is not exporting them. That's it. Over. But there is no such penalty for entering into the contract itself. That you enter into such contract, we will punish you. Here, mere entering into such contract is punishable. Differences can be summarized as follows. Basis of difference. Scope. Avoid agreement is not necessarily illegal. An illegal agreement is always void. Nature. Not forbidden under law. Forbidden under law. Punishment. Parties are not liable for any punishment under law in void agreement. In illegal agreement, parties to illegal agreements are always liable for punishment. Okay. Void agreements are not forbidden. Later on they become such. But illegals are forbidden. Okay, they are always forbidden. Collateral agreements. It is not necessary that agreements collateral to void agreements may also be void. It may be valid as well. Like we discussed in this case, he still can supply beans or he can ask 20 lakh rupees back. Agreements collateral to illegal agreements are always void. Okay, whatever happens in pursuant of the agreement is also void. Excuse me. Unenforceable contract. Okay, contracts which are unenforceable. Where a contract is good in substance, but because of some technical defect, absence in writing, barred by limitation, etc., one or both of the parties cannot sue upon it. It is declared as an unenforceable contract. Okay, where a contract is good in substance. Unenforceable means where a contract is good in substance, but because of some technical defect, absence in writing, barred by limitation, etc. Absence in writing. Okay, there may be some absence barred by limitation. Some limitation may be there. One or both of the parties cannot sue upon it. It is described as unenforceable contract. Like we discussed earlier, an agreement of insurance is necessarily to be in writing. It has to be in writing. If it is not in writing, it becomes unenforceable. That is absence in writing. Or there may be transfer of property. Transfer of property has to be not only in writing but must be registered as well. If it is not registered, then it will become unenforceable contract. A contract is there, but because of some technical defect, there was a technical defect that it was not written. Okay, or that it was not registered by the not registered under the Registration Act. So, due to these technical defects or legal defects, these contracts are now, though they are valid contracts, but have become unenforceable. They cannot be enforced. Okay, the contracts are good, but they cannot be enforced. Barred by the limitation. Barred by limitation. Or barred by the limitation, let us take just the example of that thing, the marriage thing. A contracts with the B to supply the sari to be worn on the wedding, and wedding date is 29th November 2020. But the B supplies the sari to A only by 3rd of December. Okay, now 3rd of December the contract is barred by the limitation. Why? Because now the time has elapsed. The contract was supposed to be performed by 29th of November. Now when you are trying to perform the contract, there is no time to perform the contract, so you cannot. Now the contract has become unenforceable. You cannot enforce it. Okay, or A has taken a loan from B and now refuses to pay. Okay, suppose B is bank. Okay, A is a borrower. A takes a loan from the B bank and now refuses to pay back. Now our law says that if someone has committed a default on repaying his loan, okay, law provides you. Law says you have to. Law provides you 3 years in such a case. That if in some case you are giving money to someone and he is not paying you back, you have 3 years to file a case in the court of law for returning the money. But within 3 years, if you do not go to the court, if you do not reach the court and file a case for taking the money, you are now barred by the limitation. Limitation was 3 years. Now you have crossed that 3 years limit. Now you are barred by limitation. Now you cannot file a case. Okay. So in these cases, the contract becomes unenforceable. Or A musician agrees to sing song on B's wedding for 5 lakh rupees. Okay. Now what happened? The agreement is okay. But A has contracted coronavirus. Since he has contracted coronavirus, A is quarantined and he cannot perform now. Okay, he is unable to perform. So in this case, B cannot compel A to come, and neither even if A wants to come, he cannot come. Okay, in this case, the contract will become unenforceable contract because of the impossibility.